U kunt wel plaatsnemen.
Hereby, I open this academic ceremony in which Anna de Jong will defend the academic thesis, Security Narratives, Culture and EU Law. May I invite you to present a summary of your study and the conclusions of your thesis.
Thank you, Mr. Pro-Rector, and thank you all very much for being here. It's a bit daunting look at this big a room, but I will try my best to summarize 4 years of research in no more than 15 minutes. Now, luckily for me, the first part of my title already indicates what we should be talking about first, namely security narratives, and very closely connected to that, securitization theory. Because according to this theory, security is not objective. Rather, it is subjective, based on our perception as shaped by narratives. And these narratives in turn can come from the choice for specific words or images when talking about a topic. It makes a difference, for example, whether we describe a group of people crossing the border as refugees, as migrants, or as part of a plague or a tsunami, with of course the latter terms much more indicating some kind of threat, some kind of danger. Crucially, these kind of security narratives can come from a variety of sources. They can come from the media, politicians, or anyone claiming to be an expert and being believed so. Most importantly though, these security narratives can emerge about any topic, regardless of whether it actually is a danger to us at all. And that is exactly what we saw in the second part of my PhD, focused on culture. Allow me to take you back to the years 2014-2017. Europe was in the grip of terrorism, as you can also see on the chart depicted behind me. The yellow bars show the amount of arrests linked to, at the time, the religiously inspired terrorism, ISIS, jihadists. As you can see, from 2014 to 2015, there's a very significant spike, which would last until roughly 2017. Perhaps more pointedly, though, are the black bars and the orange bars, depicting respectively the amount of deaths suffered because of jihadist attacks and the amount of attacks themselves, with 2015 and 2016 being absolute low points, with respectively 17 attacks, leaving 150 dead, and 13 attacks, leaving 135 dead. This created images such as the one you see on your right. This one was taken from the Bataclan. And these images in turn created the kind of environment where anything seemingly somehow linked to terrorism was very likely to make headlines. Terrorism was a hot, red topic. And notably around the same time when terrorism was this red-hot topic, we see these kind of narratives appearing in the media. On your left, you see an article from the BBC published in 2015. And again, take a close look at the words. Islamic State, so the most feared terrorist group, and the blood antiquity trade. Not just any trade, the blood antiquity trade. The Guardian, on your left, how Western art collectors are helping to fund ISIS. Again, this idea, this narrative of culture and terrorism somehow being linked, culture being some kind of threat. And it wasn't just British-based media who would say this story. For the Dutch speakers among you, I've selected this headline from Trouw from about the same time, proclaiming Syrian terrorists are robbing ancient heritage from musea. It didn't stop there. This is UNESCO's Irina Bakova, she was the then chair, lamenting ISIS' cultural cleansing of antiquities. Once more, words matter. Cultural cleansing, a term we associate with genocide, the biggest threat to all of us, being now used to describe culture. Again, what we see here is the start of a narrative, a security narrative of culture as a threat. But you may now be sitting here and thinking, okay, that's wonderful, but why are we talking about this as well? So what? Well, that's really where my research comes in. Because one of the main things that I learned from my research is that security narratives matter greatly. Security narratives shape policy discussions, which in turn end up shaping law. And in my research, I've shown this through several means. First off, I've shown this by looking how international law started taking over the security narrative. Because historically speaking, international law treated culture as being under threat, as you could very nicely see when looking at the preamble of some of the main legal instruments. All of them really talk about the need to protect cultural property, thereby very much aligning with the idea of culture being something vulnerable, something precious, something needing protection. However, this started changing quite significantly by 2014-2015, as we can see when looking at the United Nations Security Council resolutions dealing with culture. In 2014, we still see basically resolutions condemning the destruction, so closely again aligning with the idea of culture being under threat, culture needing protection. By 2015, though, we start seeing a different story also appear in these resolutions. It's no longer just condemnation of the destruction. It starts being combined with allegations. Allegations of culture being used to generate income for terrorists. And even later on, not just the link between culture and terrorism, but even culture being linked somehow to transnational organized crime, with the illicit trade in cultural goods being apparently as serious, as dangerous to us as the illicit trade of arms, persons, and drugs. But this is not even where it would stop. If we look at one particular notorious resolution from 2017, in the first paragraph, we again see this idea of culture and terrorism, somehow interlinked. In the second paragraph, we again see this idea of culture and the international organized crime being linked, this time also with the crimes of money laundering, bribery, and corruption. And yet in the third paragraph, we even read, culture is a threat to international peace and security. In short, what we see here is the security narrative of culture as a threat pervading international law, shaping it after itself. Crucially, though, we do not just see this in international law. This security narrative of culture as a threat ended up being especially poignant in European law. And in my thesis, I suggest two possible reasons why that is so. The first being the aforementioned already red-hot topic of terrorism being present in the EU especially. The second, though, however, had much to do with the position of culture within the EU, with culture simultaneously being too important, yet not important enough. It is too important for the member states to give to the EU, leaving the EU only a so-called limited competence to do anything relating to culture. Yet on the other hand, and also because of this limited competence, the EU, or culture better said within the EU, is given only very limited resources. This in turn has led to culture very often within the EU acting as if it is, how I called it, a solution in search of a problem. In order to circumvent the barriers established by the member states, or in order to get some of that attention, some of those resources afforded by other fields, culture was repurposed as a tool for diplomacy, as a tool for economic means, and seemingly now as a tool for our security. And concretely this ended up taking the shape of a variety of measures, two of which I have analyzed in my PhD. The first, as you can see from the very long name on the screen, is also known as the Fifth Anti-Money Laundering Directive. The second is the so-called import regulation on cultural goods. And to just immediately give away a spoiler for those of you who have not maybe already read the book, I am not quite happy with either one of them. In fact, both of them are plagued by procedural problems and ill-fitting rules. And to give you an idea of what I mean with that, I would like you to take a look at this hypothetical figurative vase. And I would like to invite you to think of yourself as the average customs or border officer. Can you tell where this is from? Is this from Italy? Greece? Syria? Can you tell how much it's worth? Is it 50 euro or is it 50,000 euro? Probably you will not know. But the problem is, to make the import regulation work the way that it is now written down, you would need to know. Because only if you know the exact heritage or the exact country of origin of this vase would you know which rules you would have to apply. Likewise, under the import regulation, only goods worth more than the so-called financial threshold actually have the rules applied to them at all. And this is another problem, where it is clear that the EU may have rushed a little bit these rules too much. Because if we have these rules in place to secure our security, but we know from the very limited research that is yet out there about potential links between terrorism and the illustrating cultural goods, that if any goods that were likely to be looted were low-value goods, then why have a financial threshold at all? I do not know, and clearly I have some problems with it, which I'm sure my opponents will like to ask me further about. Most importantly, though, what we see here are rules that are clearly affected by security narratives. Which brings me to my main findings. First off, when threats arise involving culture, they form specific security narratives, as we saw from the newspaper articles I showed you at first. Second, these security narratives appear to influence cultural policy discussions, as we also saw from the United Nations Security Council resolutions. Moreover, these cultural policy discussions subsequently appear to affect law and lawmaking, and most crucially of all, in a rather negative way, as shown from the examples of the Fifth Anti-Money Laundering Directive and the import regulation on cultural goods. You may now think, okay, this is the point where she gives the floor back to the corona, but before that I would like to make one final statement. Because so far I have been talking about culture. But crucially, this effect of security narratives is much broader than just in the field of culture. We know from securitization theory scholars that security narratives have also emerged in fields such as migration, energy, wildlife trafficking. And it appears that maybe now we are even going to see it in other fields, perhaps closer to your heart. As I was preparing this PowerPoint, I found this article from the Dutch newspaper Het Parool, claiming chocolate, honey, and mouth masks, how IS and Al-Qaeda are financing terror organizations. Dear audience, I can only hope this does not have the kind of effect as we saw with culture. I thank you very much for showing up. I thank you very much for your attention, and I will look forward to any questions the corona may have.
Thank you very much for your presentation. The opposition will now be opened by Professor Lars van Vliet. Professor van Vliet is a professor of art law at this university. You have the floor.
Thank you. Dear candidate, dear Anna, you've written an important book analyzing various international and EU instruments that aim at protecting cultural goods and combating money laundering using the art market. The focus lies on two instruments that link the trade and the import of cultural goods into the EU to financing of terrorism and organized crime. The dissertation shows in great detail how these legal instruments were formed, how the fear of certain illegal activities shaped the instruments, but it also gives detailed criticism on the technical points of the instruments and the compliance problems in practice. I'd like to express my congratulations on this achievement and this contribution to the body of art law literature. A question about the 5th Anti-Money Laundering Directive. As to this directive, you indicate that the art trade has only been added last minute and rather thoughtlessly. You add that this addition will probably remain rather ineffective, while at the same time the directive imposes a huge compliance burden on traders who are ill-fitted to bear this burden. In other words, it seems the obvious disadvantages outweigh the possible advantages. Do you think these problems can be fixed? And if yes, how? Or would you rather plead for removing the art trade from the scope of the directive altogether?
Highly esteemed opponent, thank you so much for your question. I am not pleading in favor of deregulation, far from. I am critical of these measures because I do think there is a good core to them. What I am critical of is the way that they were implemented and the way they now work out in practice, as you rightfully picked out on. Specifically the 5th Anti-Money Laundering Directive, one of the things that I would very much like to see there is more guidance for these art traders, combined with more resources for the enforcement agencies working on them. These are two of the main things that we are right now missing. As I mentioned in my PhD as well, for example, with the Paris report, we see that very often now art traders treat these rules as if they are a tick-the-box exercise. As long as we make sure that at least formally all is complied with, we think we are okay, often not quite understanding the reasoning behind these measures. Because the reasoning behind these measures is actually quite legit. Even taking apart the security angle, there is reason to believe that greater regulation can be helpful. So again, I'm certainly not against removing these rules. I do, however, feel that in practice there needs to be much work done to make them actually efficient. I hope this answers your question.
Yes, thank you. Thank you.
Given the fact that you are satisfied, the opposition will now be continued by Professor Bert de Marzin. Professor de Marzin is a professor of comparative law from the KU Leuven. We welcome you here to Maastricht. You have the floor.
Dear colleagues, first of all, very grateful for being part of this jury. I have to assume the role of opponent, and which is something I do not like to do, because I have been working with you over the past few years, and I got to know you personally, and I'm actually a big fan of what you do. This being said, however, I'm going to stick to the rule book, and I'm going to be the opponent in this jury. I'm going to question you. I hope I have the opportunity to have two questions, but I'll start with the first one. But before I do that, I just want to say that I very much liked to read your book. It's well written, it is well researched, and I want to congratulate you for that intellectual effort you took and for the addition you, as Lars said, made to the field of art law. This being said, however, in my true role of opponent, I have to say that when I read your book, it struck me, everybody who reads your book will immediately be struck by that narrative of securitization of culture, which is very much present, as you already explained. This being said, indeed, the threat of terrorism impacted the existing legal framework. You referred to the Money Laundering Directive and the regulation. Okay, it was one of your basic findings. I understand that. It affected policy, it affected legislation. Fine. But is that actually problematic? After all, one can expect politicians to act in line with what happens in society. At least that's what I expect politicians to do. It would be weird if they wouldn't do anything, and there were terrorist attacks, and we had images of archaeology being dug up and so on. Throughout your thesis, I sometimes had a strong impression that you somehow seem to have negative feelings about the securitization of culture. And I want to add one little thing. You talk about the securitization of culture. To me, culture is not securitized. It is the trafficking of culture that is securitized. as something bad. What is your actual view on that? Do you find it to be a problem, and why? Because, again, I expect legislation to be in tune with what happens in society.
Thank you so much, highly esteemed opponent. I will start with the first question. As I also mentioned in my conclusion chapter, securitization is not inherently negative, nor is securitization of culture inherently negative. It can actually bring attention to a field that is otherwise underlooked, so that you could say is a positive. The problem is, though, twofold. First off, securitization only very briefly focuses this attention on a certain field. It's basically waiting for the next crisis to emerge, and then all the extra resources that were once promised are gone, which again we very much saw with culture, or the cultural illicit trade, being washed away once COVID started and afterwards the war in Ukraine started. More problematic, though, is the influence of securitization on law and lawmaking. It's why also some of the one of the securitization scholars calls it panic politics. Because yes, I very much agree with you. We do want our politicians to respond to what is happening. We do want our politicians to actually be aware this is a threat, this needs to be tackled. The problem here, though, was that we didn't actually know whether it was a threat at all. So we might be dealing with legislation which is trying to hit a target that's not even there. More importantly, though, because of these panic politics, we see legislation that was implemented and acted upon in such a manner that crucial procedural steps were also missed. Taking the example of the 5th Anti-Money Laundering Directive, there we saw that actually the crucial step of making sure that the privacy watchdog of the European Union was also consulted was initially missed, with the idea being we need to respond now, there is this threat, we need to respond now. However, this did lead afterwards to such a massive privacy issue being part of the 5th Anti-Money Laundering Directive that for quite some time in various countries, the entire directive was cancelled or put on hold, perhaps better said. So that is why, even though I agree, securitization inherently is not a negative thing. Yes, we want politicians to respond. My PhD is still very much a plea to not forget about what procedural insights are there. Why we have certain requirements of law and lawmaking. Just because there are these feelings that we need to act does not mean we have to act right now, right there and then, and can just leave overboard any kind of proper lawmaking. Which brings me somewhat already to the second question that I may have already answered. You questioned whether I should have more rightfully have put perhaps the illicit trafficking of culture good rather than culture. I agree with you again. It is simply that sometimes as you're writing, when you're writing quite a thick book, you simply start sorting things. It would, however, be more correct to say the illicit trafficking of culture goods, that has been securitized. And kind of in line with what I said before about securitization not necessarily being a negative on its own, the securitization of illicit trafficking of cultural heritage has had its upsides. It has generated more attention. It has generated more resources. However, again, these resources turned out to be very fleeting, as we could also see from the import regulation. The idea was for there to be created this massive central system to make this regulation work. However, we are still waiting for the second IT technician to enter the room and finally actually fix the system and finalize the system. And until that time, the regulation just keeps being pushed backwards and backwards. Why? Most likely because now the funds have gone to COVID, Ukraine, whatever crisis out there, probably Israel right now. So that is why, kind of, yes, I agree with you. It would be more fair to say securitization of cultural heritage, but I would still say it is overall a negative for me. I hope that answers your question.
Yes, thank you.
As the candidate seems to agree with you, I think we can continue to the next opponent. That is Professor Arianna Visconti. She is an associate professor of criminal law at the Università Cattolica del San Cuoro di Milano. And I also welcome you very much to Maastricht, albeit on the electronic highway, as you will ask your question online. You have the floor, dear colleague.
Thank you, Prorector. And I must say thank you to Anna too, because I really appreciated her book. It is really well researched and also well written, which does not always go hand in hand. So compliments. My first question, maybe I will have a second if there is time for you, is this. As a criminal law scholar, my experience of lawmaking processes in the criminal law field makes me agree with your idea that security narratives tend to promote law policy and especially criminal law policies, which tend to be at the same time less or not at all evidence-based, and thus less effective in actually reducing crime rates, and too often also cavalier with fundamental principles and guarantees. Yet in the specific field of culture and cultural heritage, this new security narrative did not find itself conquering, as it often happens, let's say, narratively neutral ground. But instead, it found itself competing with well-rooted, strong, and equally non-evidence-based narratives, which had been dominant for long decades in the market, especially. A few examples, I'm quoting more or less, there are for sure conservation problems in many countries, but there is no proper criminal problem with culture and cultural property. One. The second, anyway, crimes occur only in the most backwards countries and they're pure police issues to be dealt with by local authorities. Third, the market takes the utmost care for the lawfulness of artworks and antiquities circulating within it. Fourth example, anyway, it is better if cultural objects end up where they can be better appreciated, better preserved, and better displayed. Also, privacy of clients and confidentiality of transactions is paramount for a smooth running of this specific market, and there is absolutely no need to sacrifice them to consideration of transparency, and so on and so forth. We could go on a lot. So I wonder, and this is my question for you, what portion of the quite suboptimal design of a legal tool like especially the 2019 European Union import regulation is to be attributed to the influence of the security narrative, and what measure, if any, instead, to stakeholders on the market side being unable or unwilling to shed these prior and equally unreliable narratives. Since good legal design requires a proper knowledge of and engagement with all relevant aspects of the reality to be regulated. According to you, was the European Union lawmaker completely deaf to reasonable and reliable counter-narratives provided by stakeholders on the market side? Or did these stakeholders fail to engage in a constructive way with the legislative process, so failed to contribute to it, possibly because they could not or wanted not to give even a little bit of ground on these narratives? Or, it's a third possibility, are both parties at fault of an excess of reliance on narrative preconceptions? Which is your take on this?
Highly esteemed opponent, thank you. I would say both parties here. But as you rightfully point out, both parties have their own narratives that they believe in and that they will espouse. I very much remember going through the discussions in the European Parliament, thriving reading, really. And what I noticed there is that very often numbers were, for example, being shouted into the room. Don't quote me on exact numbers, I'm a lawyer, numbers are not my thing. But they would claim $3 billion as being illicitly revenued each year by terrorists, by ISIS, whatever. So clearly from the European Union side, there was this strong belief in at least part of the narrative. Again, I'm simply quoting the parliamentarians themselves here. But I'm also very aware of the art market tendency to simply wave everything away and say, no, everything is fine, really leave it in our hands, there is no problem here, really just look away, leave us alone. So I understand why that might make it appear that the art market was unwilling to engage. From what I understand, though, the art market also may not have been consulted as much, which kind of brings me back to my earlier point of having very important procedural safeguards in place exactly to prevent these kind of things from happening. And exactly because the art market now seems to have some kind of legitimacy to the claim that they were not, at least in the early stages, engaged with, it has left the regulation in particular very vulnerable to criticism. Criticism that it may very much partially own, it deserves it, but some of it is actually very genuine. On the basis of the research that is out there, we have reason to believe the art market did perhaps need some regulation. It is not like the art market is the cleanest place on earth where there absolutely are no rules necessary. So again, to answer your question, in short, yes, I think really both did have their own narrative, both did very much stuck to their own narrative, and unfortunately, because of that, we now have these very ill-fitting rules.
Way,
Thank
Professor.
You. Thank you. Thank you. Thank you very much.
Excellent. That means that the opposition can be continued by Professor Roland Moerland. Roland Moerland is an associate professor of criminology and law at this university. He was also a member of the assessment committee. You have the floor.
Thank you. Dear candidate, I want to congratulate you with your manuscript, which I have read with much pleasure. It was of great criminological relevance. Your study has shown that the lens of securitization enables a more critical understanding of the legal position of culture, its relationship to criminality, and the development of regulations and directives in that regard. As such, your study, I think, is a very original and relevant contribution to the field. However, I am not only present here today to share with you my praise, it is my job as an opponent to also critically reflect on your work. And to that end, I have drawn up a question regarding the theoretical approach that you followed in your study. On page 19 of your manuscript, you note that securitization theory provided the conceptual foundation of your study. Using this lens, you examined if, how, and when cultural matters were framed as security concerns. However, your foundational application of the securitization lens also raises a critical concern. On multiple occasions, you see securitization taking place, and you conclude that the instruments that you studied are heavily affected by the preceding securitization of culture. Without this securitization, you state, these measures likely would not have been created, nor would these measures be created in the way they were. So in your study, the development of the regulations and directives is primarily explained with reference to securitization. This raises the critical question to what extent you are or have been forcing the securitization perspective on a more complex reality, to which also other alternative explanations could apply, thus running into the danger of Hineininterpretierung and oversimplification. This issue is furthermore relevant because, as you state in the beginning of your book, you are taking a grounded theory approach that operates inductively, and from that perspective, forcing concepts or theories on reality is highly problematic. I would therefore like to ask you to reflect on the potential dangers of using the securitization lens in such an all-encompassing and maybe even totalizing way. Do you recognize this danger that I might see? And to what extent might this have happened in your study? If not, how did you ensure that your foundational perspective remained an open, sensitizing lens for critical inquiry?
Thank you, highly esteemed opponents. I have to admit this is a question that, based on your feedback, your very valid feedback, I was slightly expecting. So allow me to first say that you were right in your original feedback. I was being a little heavy-handed. I have gone through the final version. It is lighter now, I assure you. But that is because I did not want to create the impression that I believe securitization is the end-all, the explanation for everything. I think, as I also mentioned in the introduction, it is helpful to see the overall picture. It allows us to see yet more of the law, but it is not the sole explanation. It is why I really made clear that I did not actually start this project at all with securitization theory in mind. This is actually a fairly late addition to the whole project. I think it was in year 3, I want to say, that Donna sent me a wonderful conference which had this random term in it, and I had never heard of it before, and I looked it up and I was like, oh, this makes sense now. And the reason why it made sense is because this project really started off much more narrow. I showed earlier on the slides, I showed these 2 measures that I really focused on, the 5th Anti-Money Laundering Directive and the Import Regulation for Cultural Goods. And that was supposed to just be the PhD. I was just going to analyze those and see, okay, the art market has criticism. Is that valid criticism? What should we think of it? And it was only while I was doing that research that I found I am not quite seeing something. There is something around it, not pervading it, but around it, shaping it. And it is then when I started really looking into, okay, what has influenced these laws? Again, without even the securitization theory first in mind. I simply started looking, okay, these measures, what do they refer themselves? And what was noteworthy there is that with both of these measures, both of them really kept coming back to this idea of terrorism in particular, organized crime. Again, the security narrative, either in the form by referencing outright the security narrative, sometimes even going as far as literally quoting the news, or by really referring back to measures which normally are only seen in the field of terrorism financing. So it is therefore that I ended up using securitization theory at all. And I think because I started from this different approach, that already makes clear that it was not my intention at all to just take this theory and run with it. So if that was an impression I gave off, I humbly apologize. Again, I hope it's better in the final version. Other than that, I hope that explains or clarifies things.
Thank you for your answer. I'm satisfied.
As I hear that you are satisfied, the opposition can be continued with Professor Sarah Schoenmakers. Professor Schoenmakers is a professor in European Economic Law at this university and was a member of the assessment committee. You have the floor.
Dear Mrs. Candidate, dear Anna, I am particularly proud of you for many reasons. Not only because you have written this very interesting book, but specifically because in my capacity as your line manager, I really have seen you grow. And even in that regard, I saw that you had great coping and organization skills. While you were still finalizing your PhD, you just took the time to write a chapter together with one of your supervisors, Professor Hildegard Schneider, for a book that I was co-editing on EU economic law and culture. So you are really a true example for many when it comes to keeping things together. Organization, coping with many different things at the same time. And I think you even show it in your defense here today. Keep calm and just defend your PhD. I think that is a quote that we really have to attribute to you. Now, my question relates to the recommendations you formulate in section 7.4 of your book. You refer, as Professor Visconti also mentioned already today, to the involvement of the widest possible variety of stakeholders, the creation of expert groups, the setting aside of overlaps between different legal instruments, etc. And in the last sentence of your manuscript, you say, rather than narrative-based policy, we should continue to strive for evidence-based policy. And I fully agree with you there. But I wonder whether you could formulate this even stronger. For example, by stipulating that the whole securitization narrative should be set aside. Of course, I understand that this narrative makes understandable why certain steps of the ordinary legal procedure were seemingly not followed, and that it allows for a greater understanding of the context in which certain measures were created. But all this seems to be exposed after the facts, after the harm is done. Would it not be better to focus on a new narrative that is forward-looking? And should this new narrative not be more than what you call an evidence-based policy, as this seems to refer to tools again, namely pieces of evidence, and not necessarily to an overall future vision or narrative on how culture should best be perceived, whatever best may be, both in general and from a legislative point of view? I'm looking forward to your answer.
Highly esteemed opponent, that's quite a question you're asking. And clearly not one I was prepared for, quite frankly. This is the part where I am not calm at all inside, but I will try my best to still calmly answer. Because your question basically boils down to how should we treat culture? How should we move on from here? How should we make sure that it's not just being used as a solution for other problems? How do we make sure culture is seen on its own? And that is such a deep question because it goes directly into the very structure of not just the EU, but I would even say the very structure of society. Because culture is one of those things where it is easy to overlook just the influence it has, because very often its greatest influence is so intangible. The reason that we are all sitting here, the reason that you are wearing that beautiful black toga and René next to you is wearing the burgundy toga, we could say is culture. But we're not likely to think of it, and we're also very much unlikely to think we need to legislate to make sure that this culture remains the way it is, if that is indeed what we want. But I think that also kind of harks to the difficulty of legislating culture. Culture is so changing, leaving again all the narratives apart, whether it's a security narrative, whatever narrative. Culture is flexible. So how should culture be done in the future, some kind of forward narrative? I would not know, and I'm not sure if there ever is going to be one concrete answer to that. But I would love to discuss it further with you.
Thank you.
Wonderful opportunity still to discuss this tonight, Madam Candidate, I would say. The opposition will now be continued by Professor Van Vliet.
In Chapter 6, you indicate that the import regulation of 2019 has a dual purpose, namely protection of cultural heritage and prevention of money laundering and financing of terrorism. You conclude that the perceived risk of money laundering and terrorism financing led to a hasty and flawed adoption of the import regulation. You indicate that there's not enough evidence of this perceived risk, or at least the size of the risk. If indeed the first purpose is actually baseless, we still have the second purpose of protecting culture. Would this second rationale be enough to support this regulation? Or would the regime of UNESCO 1970 be a sufficient alternative?
Highly esteemed opponent, thank you. The shortest answer would be no. The UNESCO Convention from 1970 is far from sufficient because the 1970 UNESCO Convention has its own problems. What is good about the 1970 UNESCO Convention is that it is widely adopted. Wonderful, we have many member states. But there is a reason why after the 1970 UNESCO Convention, we ended up with the 1995 UNIDROIT Convention. Because UNESCO itself also foresaw that there actually were some gaps that needed filling in the UNESCO Convention. So the UNESCO Convention and even the UNESCO and UNIDROIT Convention likely are not enough. Also simply because we now live in very different times. Again, UNIDROIT is from 1995. We now have the internet. That already makes it a whole different ballpark. So I do believe that protection of cultural heritage is a valid goal, is a goal that very much still needs to be met, and is a valid reason to have the import regulation. even if we, again, leave apart the security narrative, my main problem then is we are dealing with an import regulation that is very unlikely to protect cultural heritage because of all the practical problems, because of all the things that make it so the likely efficiency of it simply isn't there. And perhaps most crucial of all, we will actually never know if it is or isn't efficient. We even lack some kind of baseline that we know, okay, hypothetically speaking, were, put very simple, again, lawyer, not a mathematician, 10 illicit cultural things, were they getting into Europe, or 100? We don't know. We don't know from before the import regulation, we don't know after the import regulation. So whether it meets the goal of protecting cultural heritage, we don't know. Whether it could meet the goal, possibly, but right now it's not looking too great. Whether it's still good to have the regulation next to possibly the UNESCO Convention, the UNIDROIT Convention, any other convention, yes.
Thank you very much, Madam Candidate. Then the opposition will be continued by Professor de Marzin.
Dear Anna, I'm going to stick a bit with the regulation, a part of your book that I very much was interested in. It is indeed a rather technical issue, and I agree that what you just said, I also take that into account. Indeed, there is something good in that regulation. And I was happy, I must say, years ago when that regulation came out because there's something good in it. And I was also happy because there was an actual date in it that it would start. And I wrote it down in my agenda because it was 28th of June 2025. That would be in 4 days. The very important date, because according to Article 16, most of the regulation would start to be applicable. And therefore, my question is, and you already hinted to that or already touched upon it in answering my previous question, what is the status on the field now? But you all said it's not going to happen in 4 days. Okay, when will we be ready? What is still happening there? Are we still building towards that moment, whenever it would be, and or what is the problem? And that's rather, let's say, policy insights I'm looking for. And then secondly, assume, and I still hope, because I very much support the idea of also controlling import. What will be, according to you, if it remains unchanged and it gets applicable one day, what will be the effect on the market? Could you give me some insights, please? Thank you.
Highly esteemed opponent, I will put on my best Nostradamus hat and will try my best to first answer the question, when will we be ready? When will the system be ready? And I actually tried reaching out to the European Union to get some answer exactly on that. And unfortunately, I did not check my email today, so maybe the answer today, but at least yesterday I still did not have an answer. What we do know from earlier progress reports, which are highly technical in nature, it's a very strong level of management talk, but trying to sift through the management talk, it's not looking good. I would not be surprised if we are going to wait until 2028 for the actual full regulation to finally at least be put into effect. What the effect then will be is, again, very difficult actually to establish, because several things can happen. Taking the 5th Anti-Money Laundering Directive and how that is right now going into the field, several possibilities are there. I believe earlier in one of the questions I referenced to the core of the Thesis report, which talked about the French art market, where really the dealers simply, again, take it as a compliance exercise, tick the box, moving on. It's just paperwork, and whether it has practical effect is questionable. But again, we simply don't know. We would need to have more research for that first. So more than anything, I guess my plea is, let's not try to be Nostradamus here. Let's first actually have some proper research so that we know what is the problem right now, how is it right now looking, so that afterwards we can actually check, well, what is the effect, both on the problem itself, but also on the art market. Is the art market indeed justified to say, this is just a whole lot of red tape, why are you doing this to us? Or is it actually not at all that much a problem? Will it turn out that the central electronic system, as promised, is indeed going to solve all our problems and make the world a better place? We don't know, and that is exactly the problem. We are really working with narrative-based legislation rather than evidence-based legislation. So as much as I too would love to give you an answer, I think we will have to meet again in a few years, hopefully in Leuven over a nice beer, and then see whether we know by then.
That sounds like a charming idea, Madam Candidate.
I would love to do that.
Opposition will now be continued by Professor Visconti.
Thank you. Dear Anna, as I hinted at before, the most frequent and one of the worst risks with narrative securitization of any issue taking hold of lawmaking processes is that they result in an unreasonable compression of competing fundamental guarantees, such as, for instance, clear foreseeability of criminal responsibility and penal sanctions, or anyway punitive sanctions, given of a different nature, proportionality, and so on and so forth. Do you specifically identify any such features, both in the European Union law, so the Fifth Anti-Money Laundering Directive and the 2009 Import Regulation, maybe also in the 2017 Nicosia Convention? If yes, which ones, according to you, may be the most relevant ones? And if not, to what you may attribute this difference with the standard scenario?
Highly esteemed opponent, just to make sure I heard your question right, because it's actually slightly difficult to hear over the audio here. You are asking why there are no punitive elements right now in these measures?
Not that, no, because there are punitive elements. For instance, the regulation, as we know, asks state parties to introduce proportionate, effective, and dissuasive sanctions. But if in your evaluation of these legal tools, these measures go beyond necessary guarantees in penal or punitive matters, if yes, which are the worst aspects of these? If no, to what you attribute this lack of a standard problem with security narratives and their impact on legislation?
I think here I have to say that simply I do not know, because this is, as was pointed out by Dr. Moorland as well, it's a rather novel approach. Luckily, I'm not just having to also agree with Dr. Moorland here, but we also know from one of the most prominent scholars in securitization fields, who also mentioned we are not seeing a lot of research done yet combining, well, actually no research done yet, combining security narratives or securitization theory with EU law. So it's hard to actually make this comparison, to be able to really say, well, where else do we see security narratives? Do they there really play out the same way that I claim in my PhD here in the field of culture? I would say that it is clear that they have played a role in the field of culture, that they have helped shape the measures that I examined. I would even go as far as say they have shaped some measures which I have examined but did not have the space to put also in the PhD. But the specific comparison, I unfortunately simply cannot make, because I only got to do culture. I would love to do in future research to also focus on some of the other fields that securitization studies have already kind of pinpointed towards. That would be very interesting, where we do have reason to believe these security narratives are also so, to again kind of repeat this exercise, because I do believe this is an exercise worth doing, an exercise that is also very much worth doing in other fields. But unfortunately, I simply do not have the tools or the knowledge right now to make the comparison.
The opposition will now be continued by Professor Moorland.
So my first question concerned the first part of the book where you describe the theoretical approach. My second question concerns the impact statement and actually the last sentence of your manuscript. And I state, finally, by establishing a foundation for recognizing securitization in law, this research enables party to monitor its effects, not only in the implementation of existing policies, but also in the development of future policy making. That's a powerful statement. So my question is, what do you mean by monitoring? And how does your study enable this? Have you developed a tool, an evaluative tool? So can you reflect on this last statement, please?
Highly esteemed opponent, that's some high praise. Developing a tool when I very much did not at all start with the idea of writing a methodological book. I would love it if people took it so. I do think there is a use and a purpose to securities in theory. From my own experience, I did really see the benefits of applying it. I did feel that at least having this knowledge, being aware that security narratives are a thing, that they can be about any topic without any actual inherent danger, and that they can affect the way that we talk about things, which in turn affects the way that we legislate things. Just that awareness should already be beneficial. Whether that is by reading my book and making it into a wonderful tool, I highly promote it. I would love that. But it was not my goal when I wrote this PhD. I hope that it actually answered your question. Okay.
The opposition will be concluded by Professor Schoenmakers.
We don't have a lot of time anymore, so I will be very fast. You talk about the concept of obliged entities in your PhD, and I would like to know, as we are in Maastricht today, whether the TEFAF, the European Fine Art Foundation, would also be considered as such an obliged entity.
Oh. A very nice and local question. In short, but I would have to check. I don't think the TEFAF as an organization is an obliged entity, but all its participants directly are. That I know for sure, because they are the ones actually involved in the trade. But quite frankly, it will also really depend on how the Dutch legislator decides to read the 5th Anti-Monologue Directive, because again, it's just a directive. It will depend on the national implementation, which is where we already see differences. From what I understand right now, there is quite a wide scope of what exactly is going to be hailed as an obliged entity, because the phrase itself is a bit open. It is talking about directly or indirectly linked trades. It could be that the TEFAF would also fall under it, most likely just the art market participants themselves. But thank you so much for your question.
Thank you.
Anna de Jong, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and your defense. I request that you and your company await the results of our deliberation and our return in this room.
The PhD defense has now ended. The degree committee will debate the candidate's performance behind closed doors. This process usually takes about 10 minutes.
Long road to the south side. 7 miles in my rearview mirror, I know what it felt like. My goals only getting clearer, east side to the west side. No place like home, if it's questions that you've got, go the extra mile and that. The line, I know you know that I can't read your mind. Years can't fly by now, the way waste all your time, 'cause I'll go the extra mile. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goal's only getting clearer. East side to the west side, no place like home. If it's questions that you've got, go the extra mile and that. On the dash, got my laces tied. Long road, I don't waste no time. Break rules because fate decides. With the team and we chase the light. I make a move, fall down, shake it off. I hate to lose, bad branch, break it off. No room for negativity, praise and love. Prepare for deep part cause we're taking off. Take the mileage, traveling so far from home. Gathering knowledge, other connections. I put the time in to get everything I ever hoped for. It's a challenge and we all in. It's a better future that we go for. Even though these nights seem long, I know that I am never on my own. Know you've won the battle once you've grown. To the south side, 10 miles in my rearview mirror. I know what it felt like. My goal's only getting clearer. East side to the west side, no place like home. If it's questions that you've got, go the extra mile and that. Long road to the south side, 10 miles in my rearview mirror. I know what it felt like. My goal's only getting clearer. East side to the west side, no place like home. If it's questions that you've got, go the extra mile and that. What's on the line? I know you know that I can't read your mind. Years can't fly by now, don't waste all your time. 'Cause I'll go the extra mile.
should I get the fuck to your place?
U kunt wel plaatsnemen.
Anna de Jong. The degree committee here present has assessed the quality of your thesis and your defense. In view of its positive verdict and taking into account your previous qualifications, the degree committee has decided to grant you the degree of doctor. Professor Schneider is authorized to confer upon you this academic distinction in accordance with Dutch university custom. I invite your supervisor to now take the floor.
Do you promise to work in accordance with the principles of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee here present, I hereby confer upon you, Anna Maria de Jong, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, I now present to you with the degree certificate signed by the rector, the secretary, and the other members of the committee and affixed with the official seal of the university. And this we do. This is always the most difficult part. Congratulations. Dear Dr. de Jong, dear young Dr. de Jong, or should I say, dear Dr. de Jong, the younger. Dear Anna, it is with enormous pleasure that it is now my privilege to congratulate you here as supervisor for this fantastic academic achievement. You have written a very interesting book, everybody agreed, with many innovative insights, and you have defended your findings here today very convincingly. Actually, Donna and I were rather convinced that you would stand here as you did, calm, at least from the outside, but firm when defending your findings and recommendations. So, congratulations. Preparing this laudatio, I was reflecting a bit on how long we know each other, and when did it all started, and what to say about the process towards this beautiful final result. Looking back, I think we know each other for quite some time. I think we certainly have met while you were still at school during the TEFAF. You and also your brother have been visitors, keen visitors of TEFAF together with your father. You already showed in your high school days a very keen interest in the arts and culture. Most prominently, I remember, however, your visit to one of our master open days. We met at the cafeteria. You were reflecting whether you should continue your law studies after having finished the bachelor program at Utrecht University, here in Maastricht. We started to talk about our programs, and of course I tried to be convincing that they are very good. the various choices one could make, but very soon we were discussing our common interest in an emerging field of law, namely art law. It was very obvious that you intended to become more familiar with this field, combining your keen interest in the arts and cultural heritage with your legal studies. Whether it was this exchange of views during the open day which convinced you to do your master's studies at our faculty, I do not know for sure, but in any case, I could welcome you as a master's student of the Master Globalization and Law. After having finished this master with great success, you continued your studies in the US at Duke, and as expected, the clear intention to become a specialist in art law. When I once met your father, after your return to the Netherlands, we discussed shortly your future plans. Legal practice or academia were the opinions you were considering. Just by chance, we at MACH, the Maastricht Center for Art and Culture, Conservation and Heritage, had just won an Interreg grant called Terra Mosaic. One of the promised work packages was to prepare a feasibility study for a Euro-regional museum or culture card, and I was looking for a young researcher interested in fulfilling this task together with me. You directly showed a keen interest in this topic, and I was very happy that I found the perfect candidate, a young art lawyer, familiar with the region and the museums of the regions, speaking the languages of the region, and willing to organize meetings and workshops with the relevant stakeholders. And Sarah already mentioned your organization talent. This was the very beginning of close cooperation. During this period, we of course did not only talk about your regional museums card, but also about a possible future research topic, which could lead to a PhD project. When a call for an internal PhD procedure was opened, we, together with Donna, started drafting a project proposal which should be challenging but also feasible to finish during a PhD trajectory. For the topic, you found some inspiration in a cost proposal which we prepared together, and also together with Lars van Vliet, in 2019, dealing with various issues concerning the art market and its control. The final title of the project was Towards a Better Cultural Heritage Protection and Regulation of the Art Market, a Critical Assessment of Regulation 2019-880 on the Import of Cultural Goods in the EU and the 5th Anti-Money Laundering Directive. This PhD project proposal was prepared, and I have to mention this specifically, during the beginning of Corona. It was namely in March, April 2020. You can imagine this was a very special challenge, but we managed at some evenings on distance to discuss the proposal. In your proposal, you stated, this research project will assess the two instruments and surrounding legal framework in view of their objectives of combating money laundering, terrorism financing, illicit trafficking in cultural goods, and destruction of cultural heritage. It will provide a critical overview of current regulation and examine its national implementation and how it will affect stakeholders ranging from private actors to enforcement agencies through dogmatic and empirical legal research. With the first part of this project description, namely the critical analysis of legal instruments, you started immediately, and very successfully, I must say, by publishing your findings in relevant international legal journals. More complicated was, however, the second part, the implementation and application of the legal instruments. And that was not your fault. For this, the EU Commission, as we heard today as well, had first to take necessary measures. These Commission measures, as well as national implementation, faced, however, incredible delays until today. Meanwhile, during the research process, you have become more and more intrigued by the linkage between the fight against terrorism, the finance of them, the narrative, securitization theories, and this all in the field of culture. This was a very, as we heard also today, new and innovative aspect of your research topic. And as we can see now, it became the centerpiece of your research. You have become specifically intrigued by the security narratives which enormously influenced the political and legislative process to the two research EU instruments. With this, you have stepped on new research ground, and we have to specifically congratulate you for your courage to follow this innovative research path. Now, for the continuation of this laudatio, I would like to pass the microphone to Donna Yates, who also wants to address you here today. Before I do this, however, I would like to congratulate your family, your parents, your brother with his family, and all other relatives and friends, and fans, I would say, and congratulate her with the achievement. You all can be very proud of her.
Thank you, and I apologize to the audience. We're going to be greedy with your time. Anna is so popular that both of us have something to say, but luckily there's no defense following this, and I can claim this space. So, dear Anna, I've spent the past few weeks thinking about this speech, thinking about you as a researcher and thinking about you as a person, trying to put into feeble words why I have so much respect for you. While I still don't think I've come up with the right succinct words here, I'm not concise, I think the best way I can put it for you now is that you consider things deeply. You don't come to your thoughts and opinions lightly. You stand up for your ideas, and you regularly make me change my mind. Your ability to challenge assumptions and respectfully disagree, then engage in meaningful supported discussion, is at the very heart of the academic endeavor. It allows you to produce a book like this one that you just defended, a book that doesn't accept the status quo or the prevailing narrative as truth. It also makes you an incredibly strong colleague, teacher, champion, and friend. This PhD project, as those who have read your PhD introduction know, was born out of the pandemic. However, what the readers don't know is that our first interactions had nothing to do with a PhD. In early 2020, I had only just moved to the Netherlands and was advertising a research assistant job. Hildegard called me up to say definitively that she knew a spectacular candidate, an amazing talent, a great colleague with a great CV and expertise in art law who was already in Maastricht, and that she would have you get in touch with me. You emailed me on March 3rd, 2020 to ask if we could meet for coffee. I responded the next day saying, yes, of course, we can meet after TEFAF. And for anyone doing the math, by March 16th, 2020, we were under lockdown and we had to cancel that coffee. We settled for a call instead, and I think neither of us knew that it would be months before we met properly in person, and the first time you would see me was out the door in my pajamas. On that call, we talked for some time, and when it was over, I was very impressed with you, but perhaps not for the reason you might think. I was most impressed by how skeptical you were of the job and its fit for you, how honest you were about that skepticism, and how clear your future goals were, how insightful your questions were towards not convincing me to hire you, because I had had several of those calls, but rather towards finding out if you wanted to be hired for this. Because of this, I found myself really, really wanting to work with you. Indeed, that feeling was so strong, you can check the email record, that I emailed you back later to see if you had applied for the job, despite getting over 70 applications for the position. Okay. You didn't apply for my job. You did this instead. That's good. You applied for a PhD position in the faculty supervised by Hildegard and myself. It was funded, and I got what I wanted, to work with you. But in reflecting on this story, what I love most about it and what I respect most about you is that you didn't apply for my job. You didn't apply as a just-in-case backup if the PhD application failed. No. After research, outreach, and personal reflection, you came to the clear conclusion that my job wasn't right for you, that you had different goals, and that a not right backup plan would be a distraction. And it freed you up to focus on your PhD proposal, which was both last minute and great. And it brought you to this PhD, and now it's resulted in you having exactly the job you told me you wanted in our first conversation. This PhD here and the permanent assistant professorship you already have are a result of your deep evaluative and analytical ability. And I saw a glimmer of it in our first conversation, and it will again be the foundation of your career in the future. Here's where things are going to get soppy. I'm going to try to keep it together. Working with you has meant a lot to me. Anna, you were one of the most dependable, caring, helpful, and loyal people that I have encountered. I see your conviction and integrity as you actively support others, as a mirror of your analytical skills that make you an academic success. And thinking back to those early rough COVID times, as I personally navigated a new country, a new language, a new job, a toddler, a pandemic, not seeing my family for several years, it was hard. Yet the early interactions I had with you, how both academically stimulating but deeply kind and welcoming they were, played a major role in my deciding that Maastricht was the place for me. And it's one of the main reasons I'm still here. If I go too far into that, I'm going to get even more weepy than I am. But you are welcoming. Anna, you have that effect on people. So Anna, as I said at the start, you make me change my mind academically and often, usually about law stuff that I don't really understand. And that's something I treasure. However, regarding my initial assessment of you, you haven't changed my mind, and I still want to work with you.
Dr. de Jong, also on behalf of Maastricht University, it is my pleasure to congratulate you with the degree you just have acquired. It is, as you know, the highest degree that you can obtain in academic life, so that really merits congratulations. I also have to say that it is rare that there are so many professors present at the PhD defense, and that also the aula is that well filled. That tells something about your integration in the faculty. We know that you have done a lot for the faculty. Many years you were a member of the science committee. You now are an assistant professor, so you are already completely integrated, which is absolutely wonderful. Congratulations. I now come to a couple of practical announcements on what will happen. I understood that the reception will take place in the law faculty, most likely in the garden, given the good weather. So all of you are requested to go already to the law faculty. What will we, the committee here, do? First, with you, Anna, a picture will be taken here in the aula together with Professor Visconti, so that she can be... If you want to say hi to her, you have to look in the white one there. Yeah, there she can see you, exactly. So that is what we will first do. And then, as you know, there is a tradition that we go on the staircase and we take another picture there. And then the professors have the opportunity to congratulate you in the little corner that for a strange reason they apparently call the museum. So we thought for you it was fit to be in the museum to congratulate you. So we will go there. I think that those are all the practical announcements. And now I go to what I like most about this whole procedure. I can say this meeting is closed. Thanks.
Oh, nice holding, very good.
In, maar voor voetvast. Oh ja, voor de foto.